Justice Gorsuch?
Respond to some of the specific textual arguments on the officer of with respect to the Appointments Clause, the Impeachment Clause, and some of the others.
Yeah, so the way – I'll start with the Commission's
The ball
clause.
has been bouncing on that back and forth, and I wanted to see where you landed today.
There are three different textual inferences that could be drawn from each of those provisions Your Honor just mentioned. But the Commission's clause, I think, is the strongest because it says the President shall, commission all the officers of the United States. Shall is mandatory. All is all-encompassing. And the President doesn't commission himself, and he can't commission himself. So that's one of the first problems. I think the Anderson litigants are trying to say, there's somehow an implied exception there because the President obviously can't commission himself, so we should construe that to mean all officers of the United States besides the President. But you also have members of Congress who are not commissioned by the President, and that's because they're not officers of the United States. So the only sensible distinction that we can see, given the language of the Commission's clause, is that officers of the United States are appointed officials, and elected officials, such as members of Congress, and the President and the Vice President are not. And the Impeachment Clause reinforces that. The President, the Vice President, and all civil officers of the United States shall be removed from office upon impeachment for and conviction of all high crimes and misdemeanors. The President and the Vice President are listed separately from officers of the United States. And then, of course, the Appointments Clause, we know the President is not appointed pursuant to Article 2. Neither is the Vice President. Neither are members of Congress. So they can't be officers either.
And how does Article 1, Section 6 fit into this discussion?
And this is about officers being in the line of succession?
Yes, exactly.
Right. So you have to be an officer to be in the line of succession. We have a federal statute that puts the Speaker and the President pro tempore in the line of succession. They are officers, but they're not officers of the United States because they're not subject to impeachment, they're not commissioned by the President, and they're not appointed pursuant to Article 2. So there is this gap between the term officer and the phrase officers of the United States, reinforcing the idea that officers of the United States is a term of art that doesn't refer just to federal office holders, which is what the Anderson litigants are claiming, but refers only to those who are appointed, not to those who are elected.
Thank you.
Justice Kavanaugh?
I just make sure I understand how you're using Griffin's case again. Section 3 refers to insurrection and raises questions about who decides what processes are to be used. That's ratified in 1868. The next year, Chief Justice Chase opines that states do not have the authority, that only Congress has the authority to enforce that. That could be evidence, as you say, of the original public meaning, at least some evidence. It's a precedent, although not binding. But your point then is it's reinforced because Congress itself relies on that precedent in the Enforcement Act of 1870 and forms the backdrop against which Congress does legislate. And then as Justice Alito says, the historical practice for 155 years has been that that's the way it's gone. There haven't been state attempts to enforce disqualification under Section 3 against federal officers in the years since. So whether that's a Federalist 37 liquidation argument, it all reinforces what happened back in 1868, 1869, and 1870.
Right.
You want to add to that, alter that?
No, I think that's exactly right. And the last part you mentioned, Your Honor, is crucial to our argument, that Congress relied on Griffin's case. It provided the backdrop against which they legislated, which is why we should read these extant enforcement mechanisms, and right now the only one left is the federal insurrection statute, 2383, as exclusive of state court remedies. It's a form of implied preemption, almost C-clamor's implicit preemption of other remedies, because Congress made these decisions in explicit reliance on Griffin's case.
And if we agree with you on Griffin's case and what you've elaborated on there, that's the end of the case, right?
It should be, yes, unless Congress decides to enact a statute, which we can't rule out.
A new statute in addition to 2383. And just to be clear, under 2383, you agree that someone could be prosecuted for insurrection by federal prosecutors and, if convicted, could be or shall be disqualified then from office.
Yes, but the only caveat that I would add is that our client is arguing that he has presidential immunity, so we would not concede that he can be prosecuted for what he did on January 6th under 2383.
Understood. Asking a question about the theory of 2383. Thank you.
Thank you.
Justice Barrett?
So Griffin's case was a collateral proceeding, so it's habeas relief.
Yes.
Could Griffin have – so even if Section 3 is not a basis for collateral relief in habeas, which was new at the time, could Griffin have raised at his trial or in direct appeal the argument that Judge Sheffy, you can't legitimately sit or constitutionally sit on my case because you're an insurrectionist and you're disqualified. Could he have won then?
No.
Why?
Not if Griffin's case is correct. So a court would have to reject the rationale of Griffin's case to accept what Your Honor is suggesting.
Well, why? Like I said, Griffin's case, I think there's some language that might be a little bit broad, but at bottom, Griffin's case is about a collateral habeas proceeding. And Griffin had brought his case after the fact. He needed a cause of action. Why wouldn't it work in a trial for him to challenge Sheffy's constitutional ability to adjudicate his case?
What Griffin's case holds is that only Congress can provide the means of enforcing Section 3. And under Your Honor's hypothetical, Congress has not enacted any such statute that would give Mr. Griffin the right to raise those types of arguments at his trial. So he would have to await legislation from Congress.
Okay, let's assume that I disagree with you about the officer argument. So Section 3 covers President Trump. Let's say that Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then President Trump simply say, well, the only way to get me out of office is the impeachment process and not this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province. And you also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. The impeachment clause says that the president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. Congress can defund a position, and effectively it's not quite the same as formal removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment. But Chief Justice Marshall upheld that statute. So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Okay, let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I'm wondering, this kind of goes not to the cause of action point or the preemption point, but more to the question of what procedures he might have been entitled to. You don't make the argument that he was entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, constitutionally entitled to an opportunity to be heard. Is that right? He had no due process right?
We made that argument below. We did not make that in our briefs to this court for several reasons. Your Honor, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was just
asking. I'm sorry. The question seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling specific to this particular proceeding in the state of Colorado and would leave the door open for Colorado to continue on remand to exclude him from the ballot.
Okay. Thank you.
Justice Jackson?
To whether the presidency is one of the barred offices, I guess I'm a little surprised at your response to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason for why the presidency may not be included. And by that I mean I didn't see any evidence that the presidency was top of mind for the framers when they were drafting Section 3, because they were actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists into the state government apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in local offices or as representatives of the states in Congress. And that's a very different lens. If your concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction, seems to me very different than the worry that an insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
There is some evidence to suggest that.
Is there any evidence to suggest that the presidency was what they were focused on?
There is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president. And there was also one of the drafts of Section 3 specifically mentioned the presidency and the vice presidency.
But it wasn't
but
it wasn't the final
It wasn't the final.
So
it wasn't. Yes,
right.
I'm sorry. It wasn't the final enactment, but it does show that there was some concern by some people about Confederate insurrectionists ascending to the presidency. And we didn't want to make a law office history type argument where we just look at the historical evidence and pick the evidence that we like and interpret it tendentiously, because the other side can get back with us and throw this countervailing evidence back in our face. So we wanted to focus more on the text of the Constitution because this was ultimately a compromise provision that was enacted in Section 3.
All right. Let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. Mm-hmm. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this Court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement.
That's correct.
All right. Final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection. As defined by Section 3, and I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be what is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so
riot
your point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection as that term is used in Section 3.
Thank you.
Thanks.
Thank you, counsel.
Thank you.
Mr. Murray?
Mr. Chief Justice, and may it please the Court, we are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting President of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this Court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the Court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States. But this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal ignore the constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots by excluding those who are underage, foreign-born, running for a third presidential term, or, as here, those who have engaged in insurrection against the Constitution in violation of their oath. I welcome the Court's questions.
Do you have contemporaneous examples, and by contemporaneous I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been – states certainly wouldn't have the authority to remove a sitting federal officer. So what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples? Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections, they didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges, immunity. They won't deprive people of property without due process. They won't deny equal protection.